Will the insurance companies have access to past and present medical history and treatments, and can they use that as part of their defense to avoid paying out on my injury claim? Attorney George C. Creal explains, if you've been involved in an automobile collision, wreck, or accident, and you file a lawsuit, then you will typically be subject to what's called discovery, which by Georgia statute lasts for 6 months after the defendant files their answers to the lawsuit and can be extended. The discovery period is a period where the defendant, through their attorney, who is usually hired by the insurance company to represent the other driver, has a right to send written questions, request documents, and have an in-person question and answer session called a deposition. The deposition is sometimes video recorded and is transcribed by a court reporter. Georgia law does allow for the defense to ask questions about prior medical treatment and prior injuries that may have some impact on your current injury case's value. However, just because you were injured before doesn't mean you can't sue, as long as your injury was aggravated or increased by the current automobile collision. Take the safe road by hiring attorney George Creal and his team, who bring over 50 years of courtroom experience to counsel's table, providing your case with the individualized time and attention to detail required for success.